The judge finalized our divorce a month ago. My ex-husband decided to move out without any notice, and then he turned off all utility services. Can he legally do that without telling me and giving me notice? It's a great question, happens quite a bit. And the answer is it depends upon 1, the rules and statutes that apply in your jurisdiction, and 2, the provisions of your decree of divorce, and related orders if your jurisdiction divorces end with multiple orders as opposed to all the orders in one decree of divorce document. For example, in the jurisdiction where I practice divorce and family law, which is Utah, there is no law that specifically prevents a divorced spouse from canceling the accounts for the household utilities, asterisk here. Indeed, if in a divorce proceeding the house is awarded to one of the spouses and the other spouse must now move out, many such divorced spouses have good reason for canceling the accounts for the household utilities. And what is that reason? To ensure that they are no longer billed and held liable for utilities for a house in which they no longer reside. If the provisions in your decree of divorce and related orders, if in your jurisdiction divorces end with multiple orders as opposed to all the orders in one decree of divorce document, if they prohibit one's ex-spouse from canceling or otherwise interfering with the other's utility services, then the affected spouse could move the court to hold the offending ex-spouse in contempt of court and seek to have the offending ex-spouse sanctioned for contempt. Now, clearly, there are usually better ways of handling the situation than secretly closing the accounts and not notifying the ex-spouse until after the fact, or not telling the other spouse at all and letting him or her discover it on his own. But just because it's ill-mannered does not make it illegal. And if there is no provision in the decree of divorce or related orders that doesn't expressly prohibit you and your ex from canceling the utilities that are presumably in your joint names, because presumably you opened those accounts when you were married to each other, there may be nothing, and there likely is nothing, that you could do through the courts to punish your ex-spouse for his or her actions. Now here's the asterisk. If a divorced couple has minor children, it might be possible to argue that cutting off the utilities to the house could constitute child abuse under Utah Code Section 76-5-109. If the couple has a disabled child, one might argue that canceling the utility accounts is abuse or neglect of a disabled child. See Section 76-5-110. I don't know if one could argue that canceling the utilities to the house could be construed as criminal mischief, as defined in Utah Code Section 76-6-106 sub 2 sub B, Romanet A or B or Romanet 2. But you may want to look at those if it's really that big of a concern to you.